Under the Uniform Commercial Code, or UCC, a buyer in the ordinary course of business takes free of any security interest created by the buyer's seller. The Wisconsin Supreme Court considered when a car buying couple became buyers in the ordinary course of business in Daniel versus Bank of Hayward. Joseph and Marijane Daniel visited a car dealership where they agreed to purchase a new Chevrolet van that still needed to be manufactured and delivered to the dealership. Under the contract, the Daniels owed about $3.4 thousand on delivery, the difference between the cash price of the van and the trade-in allowance for their motorhome. Subsequently, the dealership ordered the Daniels' van from General Motors, or GM, and GM charged the dealership's inventory financer, Bank of Hayward, for the van. Then the bank prepared and the dealership signed a floor plan promissory note worth about $9.9 thousand to pay GM for the van. Through that promissory note, the bank received a security interest in the van. After the van was delivered to the dealership, the bank became aware that the dealership was getting rid of used cars. The used cars in question were securing the bank's loans, so the bank demanded immediate repayment of the loans and took over the dealership, preventing any cars from leaving the dealership lot. When the Daniels went to the dealership, the bank refused to release the van unless they paid off the promissory note in full. The Daniels borrowed money from the bank to pay off the promissory note, taking title to and possession of the van before suing in Wisconsin state court to recover the amount that they overpaid. The trial court entered summary judgment for the bank, concluding that the bank's perfected security interest in the van had priority over the Daniels' interest. The reason was that, at least until title passed, the Daniels weren't buyers in the ordinary course of business. The Wisconsin Supreme Court agreed to take the case.